I want to read my prosecutor's motion that he submitted today. This will be the first time I read it. I just simply copied and pasted everything, threw it in ChatGPT, and then asked ChatGPT to do the rebuttal and all that. I didn't even really read this, so I'll be reading it for the first time. I've already submitted my response, but I rely on ChatGPT to just take care of the business for me, at least the paperwork business. Alright, so let's get familiar with this. Alright, I got my email. Please take notice that the Village of West Milwaukee by Assistant Village Attorney Christopher R. Schultz hereby moves the court for the admission of other acts, evidence, and prohibition of use of artificial intelligence at trial in the above captioned matter for the following reasons. Other acts, evidence. The defendant, Travis Hines, has pending citations for loitering, prowling, and resisting obstructing a police officer. The basis for these citations are the village's allegations that the defendant was present in the parking lot of a closed business in the village of West Milwaukee, and that when asked to identify himself by a Village of West Milwaukee police officer investigating his presence, he repeatedly refused to provide his full name or identifying documentation. The village moves pursuant to a Wisconsin statute 904.042 State v. Sullivan from 1998, as well as other relevant Wisconsin case law for the admission of evidence of numerous other instances of the defendant parking where prohibited and refusing upon request to identify himself to law enforcement. The village asserts that such evidence is relevant pursuant to Wisconsin statute 904.042 State v. Sullivan from 1998 on the issues of absence of mistake, intent to provoke an encounter with law enforcement, and a plan to video record the encounter. The Wisconsin Supreme Court has indicated that courts should not be predisposed against admission of other acts evidence. Wisconsin statute 904.042 favors admissibility in the sense that it mandates exclusion of other acts evidence in only one instance, when it is offered to prove the propensity of the defendant to commit similar crimes. State v. Spear from 1993 allows the admission of other acts evidence of other crimes, wrongs, or acts when offered for purposes such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. The list of permissible uses under Section 904.042 is illustrative, not exhaustive. Permissible purposes that have been recognized which are not listed under Section 904.042 include other acts evidence offered to furnish part of the context of the crime or that may be necessary for the state's full presentation of a case. See State v. CVC 1989, State v. Schultz 1983, something in 1984, to explain background relationship of parties which was necessary to understand the context of the case. Sullivan sets forth the three-step analysis a court must conduct when faced with a motion on other acts evidence. First, the court must determine whether the evidence is being offered for an acceptable purpose under either the exceptions set forth in 904.04 or whether it furnishes part of the context of a crime or is necessary for a full presentation of the plaintiff's case under State v. CVC and or State v. Schultz if the other act's evidence qualifies under any of the allowable reasons previously mentioned. The court looks to the second step to determine if the evidence is relevant under Section 904.01 Sullivan. 904.01 states that relevant evidence is defined as having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable than it would be without the evidence. Information regarding the defendant's numerous other similar encounters with law enforcement are necessary for the court to consider. The defendant's other acts show that he was not mistakenly a suspect in West Milwaukee and show he had intent to create video content of his interactions with law enforcement and a plan as to how to do so. Thus, the defendant's other acts' conduct is relevant and necessary for the village to prove that the defendant lacked a genuine misunderstanding or mistake in his actions in the case at hand, as well as his intention and the plan to create video content of his interactions with law enforcement. After the second step, the court moves to the final analysis to determine whether the probative value of other acts' evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence under Section 904.03, Sullivan something. In the instant matter, the village seeks to introduce the other acts' evidence on the issues of absence of mistake and therefore qualifies under the exceptions outlined in 904.042. The Supreme Court has approved the use of other acts' evidence to demonstrate motive. See State v. Hunt and State v. Plymesser, both from 1992. The final analysis for the court to consider is whether allowing in the other acts' evidence creates an unfair prejudice to the defendant. The prejudice must be unfair, and the danger of unfair prejudice must substantially outweigh the probative value of the evidence. The Supreme Court has stated that evidence is not unfairly prejudicial merely because it damages the opposing party's case, since that is the very purpose of relevant evidence and litigation. See State v. Bedker from 1989. Courts have repeatedly noted that any prejudice resulting from the admission of other acts' evidence may be cured by the use of cautionary instructions to a jury as contemplated by the Wisconsin Jury Instruction number 275, Huddleston v. United States in 1988. The evidence is highly relevant as to absence of mistake and is necessary for the jury to assess the charged offense in the proper context. In Plymesser, the Supreme Court approved the admission of other acts' evidence, even after determining it was enormously prejudicial, but also noting it was extremely relevant. Plymesser at 587. The state would anticipate introducing this evidence through only one witness, Travis Hines. Therefore, the evidence would not be cumulative or present undue delay under the considerations of Wisconsin Statute 904.03. Request to prohibit use of artificial intelligence at trial. The defendant has stated an intention to use artificial intelligence to listen to his upcoming trial and to use it to formulate objections during trial. These statements were made in a video published by the defendant. The defendant's statements regarding his intended use of artificial intelligence are found at timestamps 4 to 6:30 in the defendant's video. The undersigned is unaware of any artificial intelligence being licensed to practice law in the state of Wisconsin. The undersigned therefore believes that use of artificial intelligence at trial is improper and poses a risk of significantly delaying the proceedings. Further, the defendant's stated intent to have artificial intelligence listen to the trial will likely violate the court's standing order regarding recording of court proceedings. For the reasons set forth above, the undersigned asks the court to allow the other act's evidence on the issues of the defendant's absence of mistake, presence of intent and plan, finding that the probative value of the evidence is not substantially outweighed by the risk or danger of unfair prejudice, and prohibiting the use by either party of artificial intelligence at trial. In the alternative, the undersigned requests trial to be conducted in person to ensure no artificial intelligence is used. All right, and that was what he sent, and I have my response. Maybe I could put that in a different color just so that's color coded. I'm going to select all and put it as yellow, just so that it's clear it's different. Okay, what I found interesting was that he emailed this Veronica Munt. I looked her up, and she was some kind of a clerk for the on public records, in the public records that ChatGPT found. She was a clerk in 2018 or something. Some kind of well, let me just pull it up. Let me just pull it up. She was a clerk dispatcher, let's see, for the village of West Milwaukee in 2018 and 2019, or she could be dead. The clerk dispatchers coordinates the timely, efficient delivery of goods and services. So, you know, I don't know why he was emailing her. But she was a part of the email, as long as, you know, as well as Richard Fonz, and then himself, he's there, and then me, of course. We're all in this email loop. All right, and this is my response, and I responded in the Google Docs, so it's actually in Times New Roman. I copied and pasted. I made my boxes to separate everything. So it's in it's in black and white here too? Okay, I forgot that it would do that. Maybe I can make it bigger. Alright, we'll read it through this one then, since it's more proper looking. So, okay, it does look like this, the defendant versus the plaintiff, but I don't know, I think that's a minor issue. So this is exactly what I PDF'd off to the court not too long ago. Defendant's response to prosecutor's motion to introduce other acts, evidence, or prohibit use of artificial intelligence. Comes now. The defendant, Travis Hines, and respectfully submits this response in opposition to the plaintiff's motion in support thereof. The defendant states as follows. Counter arguments to the case law cited. I just simply asked ChatGPT to make counter arguments for everything. The plaintiff relies on Sullivan to justify the admission of evidence concerning the defendant's prior encounters, arguing that such evidence is admissible to demonstrate intent, absence of mistake, and planning. Defendant's counter-argument. The defendant contends that the factual circumstances in Sullivan are distinguishable from the present matter. The proposed evidence appears aimed at establishing a general propensity for misconduct rather than addressing any specific element of the current charge. The defendant submits that this constitutes an impermissible attempt to prejudice the jury by inferring a criminal character rather than proving relevant issues in the case. Alright, and then State v. Spears. Prosecutor says the prosecutor cites Spear to support the admission of prior acts evidence, asserting that it is acceptable, if not used solely, to show propensity. My argument. The evidence at issue appears primarily intended to suggest a habitual propensity to engage in misconduct. This application is contrary to Spear's clear limitation against using such evidence merely to imply a propensity for criminal behavior. The defendant therefore argues that the evidence should be excluded as it fails to meet the narrowly tailored exception and serves only to bias the jury against him. Okay, and then they got a couple of cases here. The prosecutor's position. These cases are invoked to assert that other acts evidence may be admissible when it provides necessary context or background to a crime. My counter-argument. The defendant submits that the contextual relevance of the cited past incident is remote at best. Rather than illuminating any specific element of the charged conduct, such evidence is being introduced solely to evoke a negative impression. The defendant contends that this approach is an abuse of the context exception and risks unfairly prejudicing the jury. Alright, prosecutor says the plaintiff or the prosecutor relies on Hunt to justify using other acts evidence to establish motive with State v. Hunt. Defendant's counter-argument. The defendant argues that inferring motive from unrelated prior acts is inherently speculative. Motive in the present case should be determined solely in the evidence directly related to the charged incident, not on an alleged pattern derived from disparate occurrences. Therefore, the admission of such evidence is improper. State v. Plymesser from 1992. The prosecutor's position. Plymesser is cited to argue that even highly prejudicial evidence may be admitted if its probative value is significant. Defendant's counter-arguments. The defendant contends that while relevance is a factor, the overwhelmingly prejudicial impact of the proposed evidence substantially outweighs any minimal probative value. The risk that the jury will base its decision on an inference of criminal character rather than the facts of the current charge is too high. Jury instructions cannot fully mitigate this danger. Let's see, statutes, prosecutor's position. The plaintiff argues that under these statutes, 904.04 and 01, the evidence is relevant because it tends to make certain facts more probable. Defendant's counter-argument. The defendant maintains that while the statutes permit the admission of other acts evidence for limited purposes, such as establishing intent or absence of mistake, the evidence in question does not meet these narrowly defined criteria. Instead, it is being introduced to suggest a general criminal disposition, which is expressly prohibited by the spirit and letter of the statutory framework. Request for additional time and a personal hearing. In-person hearing request. The defendant, Travis Hines, is currently residing in Texas. Given the gravity of the motion and the potential prejudice involved, the defendant respectfully requests additional time to arrange for an in-person hearing. An in-person proceeding is essential to ensure that the defendant's arguments and rights are fully and fairly presented. And that's fine by me, I just need more time. YouTube video context and relevance. The plaintiff's motion cites a YouTube video in which the defendant is purported to have expressed an intent to use artificial intelligence during trial. The defendant asserts that the video is taken entirely out of context. In his videos, he routinely employs humor, imaginative storytelling, and random commentary. There is no factual basis to interpret these statements as serious legal strategy or intent relevant to the current charges. The defendant requests that the court consider the context of his speech and dismiss any conclusions drawn from this video as evidence of a substantive plan. Demand for disclosure of specific evidence. The defendant further demands that the plaintiff provide specific details and evidence regarding the prior incidents referenced in the motion. Classification of past conduct. The defendant is entitled to know precisely which incidents the prosecution is relying on to establish his alleged propensity, intent, or planning. Brady obligations. If this constitutes new evidence intended for use at trial, the defendant reminds the court of the plaintiff's obligation under Brady v. Maryland to disclose exculpatory evidence. The defendant must be given full access to this evidence to prepare an effective defense. Conclusion. For the foregoing reasons, the defendant respectfully requests that this court, and then I put double spaces to make it stand out more, deny the plaintiff's motion to admit other acts evidence, as its prejudicial effect substantially outweighs any limited probative value it might offer. Deny any motion to prohibit the use of artificial intelligence based on a misinterpretation of a contextually ambiguous YouTube video. Grant the defendant additional time for an in-person hearing given his current residence in Texas, and order the plaintiff to provide a detailed disclosure of the specific evidence and incidents being relied upon in accordance with the defendant's rights under Brady. Alright, and this is my information. And, oh man, okay. In the Municipal Court, I guess this should have been here, I guess. Oops. Oh well. Alright, so this is another page I got. I made an order. I don't know how it is in Wisconsin, but Louisiana, they ask you to write an order for the judge to sign because you serve the judge more. So I did that. So I made this order, and it's worded pretty neat. It's differently worded, and then also Louisiana kind of requires a certificate of service. So I put that for Wisconsin. I don't think it hurts. That's something that Schultz didn't do. So that's it. That's his motion. This is my response to prosecutor's motion. All in a day. He submitted it at 4. I gave my response by about 6:30. Maybe he was more like 4:30. It took about 2 hours for me, and I didn't even see the email until about 5 anyway. And so I barely read it. It was copied, pasted, moved everything into ChatGPT, asked it to put some arguments, and then sent it out. That was it.